a petition with hundreds of thousands of signatures, a political movement that took years to build, a plan to put the very existence of Alberta on the ballot, all of it brought to a sudden grinding halt by a single court ruling. But this isn't just a story about a judge striking down a piece of paper. This is a story about how the quiet, often invisible pillars of Canadian law can suddenly rise up to block even the most powerful political winds. Now, the specific case we're about to break down, involving a group called Stay Free Alberta and a hypothetical Justice Shayna Leonard, hasn't actually happened in this exact way. But by treating it like a case study, we can unpack the very real, incredibly complex legal tripwires buried just beneath the surface of Canadian politics. This fictional scenario is the perfect lens for understanding a monumental collision that could happen, a clash between popular democracy, the supreme law of the land, and the deep foundational rights of Indigenous peoples. So, how could a movement for independence, seemingly powered by the people's will, fall apart so completely in a courtroom? To understand the legal explosion, you first have to understand the political fuel. For years, Western alienation has been a constant in Alberta's political climate. It's a deep-seated frustration that the federal government in Ottawa doesn't understand, or maybe just doesn't care about, the province's economic and cultural realities. This isn't new. It has roots going back decades, fueled by fights over the National Energy Program in the 80s, endless arguments about equalization payments, and recent battles over federal carbon taxes and energy projects. For many Albertans, it feels like they're a vital economic engine for the country, but are constantly punished by federal policies they have little say in. From this discontent, various independence movements have risen and fallen. In our hypothetical story, the most prominent is Stay Free Alberta, led by a figure we'll call Mitch Sylvester. This group is organized, media-savvy, and focused on one legal tool they believe is their path to a vote: Alberta's Citizen Initiative Act. This act is real. It lets ordinary citizens propose a new law or even a referendum on a constitutional question. If they get enough signatures, the government has to deal with it. It's a tool for direct democracy. For Stay Free Alberta, it was the perfect weapon. They drafted a simple question: do you agree that the province of Alberta should cease to be a part of Canada to become an independent state? The goal was clear: get that on a ballot. They launched their petition drive on January 2, 2026. They held rallies, knocked on doors, and lit up social media. And it worked. On May 4, 2026, they dropped off boxes at Elections Alberta containing what they claimed were over 300,000 signatures. This was their moment. They had harnessed popular frustration and channeled it through the legal process. Next up, Elections Alberta would verify the signatures, and a referendum seemed inevitable. But what the organizers failed to see were the much larger forces they had just awakened. Their petition wasn't just a political document, it was a legal trigger, and it had just set off alarms in the deepest, most fortified parts of the Canadian legal system. To see why this legal firestorm was brewing, we need to look at what the provincial government itself, led here by Premier Danielle Smith, did to pave the way. Let's imagine that in late 2025, a previous, less organized separation petition was rejected by the Chief Electoral Officer, a man we'll call Gordon McClure, because the question was unconstitutional. This would have infuriated the independence movement. So, in our scenario, Premier Smith's government makes two huge changes. First, they amend the Citizen Initiative Act. Yours. The real act has a high bar for constitutional questions, requiring signatures from 20% of all eligible voters. But in our hypothetical, the government tables a bill that dramatically lowers the threshold to just 10% of the votes cast in the last election. This is a massive change, making it exponentially easier to trigger a referendum by slashing the required signatures. They also extend the gathering time from 90 to 120 days. They'd call it democratic renewal. Critics would call it greasing the wheels for a separation vote. Second, and this is the big one, the government amends the law to stop the chief electoral officer from blocking a petition just because the question might be unconstitutional. The new logic is, let the people sign, let the vote happen, and we'll worry about the constitutional mess later. The Premier might argue, it is not for an unelected official to block the democratic will of the people. With these changes, the floodgates opened. The chief electoral officer, Gordon McClure, now operating under these new rules, gets the Stay Free Alberta petition. He knows the question is a constitutional minefield, but the new law says he can't reject it on those grounds. The signature threshold is now easily met. His hands are tied, he approves the petition process. On the surface, a win for democracy. But what the government had really done was create a paradox. It used its power to create a system that encourages a question fundamentally at odds with the Canadian Constitution. They built a political off-ramp from Canada but ignored that it leads directly into a legal brick wall. This is the first crucial point a court would later seize on. The government itself had knowingly created a process to bypass constitutional scrutiny, setting up an inevitable conflict. The petition might have been approved under Alberta's new rules, but provincial laws don't exist in a vacuum. They sit inside a much bigger, more powerful framework, the Constitution of Canada. The question of whether a province can just leave Canada was tackled head-on by the Supreme Court in a landmark 1998 case, the Referendum secession of Quebec. After the razor-thin 1995 Quebec referendum, the federal government asked the top court to clarify the rules. The court's answer was complex but decisive. First, a province cannot secede unilaterally. There's no breakup button in the Constitution. A province can't just vote and walk away. That would be illegal under Canadian law. On the international stage, the court noted that a right to secede is generally reserved for situations like colonial oppression, which didn't apply to Quebec. But the court also said democracy is fundamental. If a province held a referendum with a clear majority, voting on a clear question to secede, the rest of Canada would have a constitutional duty to negotiate. That's the balance. A vote to leave doesn't trigger independence. It triggers an obligation to talk, and those talks would cover everything: debt, assets, borders, minority rights, and, crucially, the rights of Indigenous peoples. Following this, the federal government passed the Clarity Act in 2000. This law basically implements the court's opinion in federal statute, giving the House of Commons in Ottawa the power to decide if a referendum question is clear and if the result is a clear majority, implying 50% plus one might not cut it. Now, back to our Alberta case. The legal challenge against the petition, led by First Nations, would lean heavily on this framework. Their lawyers would argue the whole process was unconstitutional from the start. They'd say the Alberta government was trying a do-it-yourself secession, which the Supreme Court had already ruled out. And they'd argue that the Premier's new law, the one saying a question doesn't have to be constitutional, was itself an unconstitutional act. A province can't just pass a law to ignore the Constitution. It's like a city passing a bylaw that says it no longer has to follow national laws. The statute can be passed, but it won't have legal effect when challenged. This is the heart of the conflict for our judge, Justice Shana Leonard. She's faced with a provincial law that says go ahead, and a body of Supreme Court precedent, and federal law that says not so fast. Her key finding on this point would be that Elections Alberta, by approving a petition that ignored the established constitutional rules, had acted unreasonably. Even with his hands tied by the new provincial law, the chief electoral officer is still bound to uphold the entire legal framework of Canada. By starting a process on a collision course with the Constitution, the approval itself was legally flawed. While the constitutional conflict was a huge hurdle, the argument that would prove decisive came from a different, powerful source: the rights of Indigenous peoples. This is where the story pivots from a federal-provincial fight into something far more profound. The legal challenge was led by a coalition of First Nations, including the Athabasca Chippewayan First Nation and the Blackfoot Confederacy. Their argument wasn't just that Alberta separation was a bad idea, it was that the process of even considering it, without them, was illegal. To get this, we need to talk about two massive concepts in Canadian law: treaties and the duty to consult. First, the treaties. The land that is now Alberta is covered by historic treaties like Treaties 6, 7, and 8. These aren't just artifacts, they are legally binding, nation-to-nation agreements between the Crown and sovereign Indigenous nations, protected by Section 35 of the Constitution. Then there's the duty to consult. Developed by the Supreme Court, this legal principle flows from the honor of the Crown. It says governments must consult with Indigenous peoples and accommodate them where appropriate, whenever a government action might negatively affect their rights. This isn't a suggestion, it's a constitutional command. Here's how the First Nations lawyers connect this to the petition. They would argue that Alberta leaving Canada isn't a simple political shuffle. It's a catastrophic threat to their treaty rights. Their treaties are with the Crown, represented by Canada. If Alberta secedes, who upholds those promises? A new Albertan republic that never signed them? The very idea of secession creates a profound legal black hole for every treaty right they hold. This profound uncertainty is the problem. Therefore, they'd argue, the duty to consult was triggered. Not after a yes vote, but at the very beginning, the moment the government contemplated a process that could lead to this outcome. The government's lawyers would counter that the petition is just an administrative step, just gathering names. They'd claim the duty to consult only kicks in much later. This was the central question for Justice Shana Leonard. When does the duty to consult begin? Her hypothetical ruling would be groundbreaking. She would reject the government's argument, saying it was an attempt to put the constitutional cart before the horse. She'd find that by changing the law to specifically grease the wheels for a separation referendum, the government had already taken an action that could realistically harm treaty rights. The process and the outcome are tied together. In her fictional but powerful words, she might have written, "The Crown cannot light the fuse on a constitutional bomb and then claim it has no duty to consult with the people living at ground zero until after the explosion." She would rule that the Chief Electoral Officer's decision to approve the petition was unreasonable because it failed to recognize that the Crown's duty to consult had already been triggered. By ignoring this fundamental obligation, the entire process was flawed. It was a stunning legal victory for the First Nations and a fatal blow to the petition. The fictional ruling by Justice Shana Leonard would land like a thunderclap. For the First Nations, it would be a moment of profound vindication. As you imagine Chief Allan Adam of the Athabasca Chippewayan First Nation, a real and influential leader, calling it a historic victory for the rule of law and for treaty rights. He might say, "This decision confirms what we have always known. You cannot remake this country without the free, prior, and informed consent of the Indigenous peoples." A representative from the Blackfoot Confederacy, like Chief Troy Knowlton of the Piikani Nation, might add, "This is not about blocking democracy. This is about ensuring any conversation about the future of this land respects the sacred promises in our treaties." On the other side, the reaction would be swift and furious. Mitch Sylvester of Stay Free Alberta would denounce the decision as a betrayal. Over 300,000 Albertans asked for their democratic right to be heard, he might say. And one unelected judge has decided their voices don't matter. This is the very reason we need to be our own country. His lawyer, Jeffrey Rath, would likely vow to appeal. The biggest reaction, though, would come from Premier Danielle Smith. She would see it as a direct political attack. "We are witnessing a profound assault on democracy," she might state. The court's decision is, in our view, incorrect in law and fundamentally anti-democratic. She would immediately announce an appeal, framing it as a fight for the rights of Albertans to even ask questions about their future. And Ottawa. Let's imagine Prime Minister Mark Carney is in office. His response would be cautious. Alberta's best place is within a strong and united Canada, he might tell reporters. Provinces must follow the rules. That means respecting the Constitution, the Clarity Act, and the rights of Indigenous peoples. A calm, clinical statement designed to highlight the gulf between the two governments' views. The court case wouldn't have ended the conflict. It would have simply moved the battle into a new, even more intense arena. So, what does this fictional saga teach us? It reveals the hidden architecture of the Canadian state, an architecture far more complex and resilient than many realize. It shows us that in Canada, democracy isn't just simple majority rule. The idea of letting the people vote operates within a system of constitutional guardrails. These guardrails, the rule of law, minority rights, the honor of the crown, aren't bugs in the system. They are features. They exist to prevent a tyranny of the majority. And maybe most importantly, this scenario puts a spotlight on the undeniable central role of Indigenous peoples and their rights in 21st century Canada. Through decades of struggle, First Nations, Métis, and Inuit peoples have successfully established that their rights, enshrined in the Constitution and affirmed in treaties, are not a secondary issue to be dealt with later. As our hypothetical case shows, the duty to consult isn't a checkbox, it's a foundational obligation. The idea that a province could secede from Canada without the deep, early, and meaningful involvement of the Indigenous nations whose lands and rights would be irrevocably affected has been shown to be a legal and political fantasy. This fictional battle lays bare the central challenge for any modern independence movement. It's not just about winning a PR campaign or a referendum. It's about navigating a legal labyrinth designed to protect the integrity of the country and the rights of all its peoples. The real-world frustrations fueling Western alienation are legitimate, but as our case study shows, the path to secession isn't a simple highway. It's a field of legal landmines. The question for any future independence movement is no longer just, can we win a vote? But can we untangle a web of constitutional obligations, federal law, and treaty rights that are over 150 years in the making? Because in Canada, the past is never truly past, and the law has a very long memory.